Dispute Resolution. I'm Sean Murphy. I'm the president of the American Society of International Law, and I'm delighted to have everyone here for what has become a signature event of our annual meeting. I'd like to acknowledge first Charles Brower's support for the Society over the years, which is why the Society has decided to call this lecture the Brower Lecture in International Dispute Resolution. This is the seventh annual Charles M. Brower Lecture, and it's been an illustrious array of speakers that have guided us in this lecture over the years. Individuals such as Johnny Veeder, Sundaresh Menon, Professor Michael Reisman, who is here, Gabrielle Kaufman-Kohler, David Karen, and last year's speaker, Meg Kinnear. I'm very delighted that we have this year with us Judge Peter Tomka of the International Criminal Court. I think I'm about 2 hours ahead of my next introduction, which will be the president of the International Criminal Court. But at least I know I have everyone's attention, including, of course, Judge Tomka, who I will note is of the International Court of Justice, and its former president, in fact. Judge Tomka served as an assistant legal advisor and later head of the Public International Law Division of the Foreign Ministry of Czechoslovakia, and as legal advisor to its United Nations mission. He continued his work in the field after the birth of his new country of Slovakia, and served as that country's deputy permanent representative, and then later Slovakia's ambassador to the United Nations. He returned to his country to serve as the director of the International Law Department at Slovakia's Ministry of Foreign Affairs, during which time he served as agent on behalf of Slovakia in various proceedings, including in the case involving the Gabčíkovo-Nagomoras project at the International Court of Justice, which my students often remind me is still on the docket of the court, and they often ask me, why is that the case? Judge Tomka served as a member of the UN International Law Commission before being elected to the International Court of Justice in 2003. He was at one time the president of the International Court. He's also an honorary member of the Slovak Society of International Law, and we here at the American Society are very honored to have him serving as a counselor of the American Society of International Law. Judge Tomka's topic for today's lecture is A Century of Dispute Settlement Through International Law, 1919 to 2019, the Role of Multilateralism. Please join me in welcoming a judge from the International Court of Justice, Judge Peter Tomka.
Thank you very much, Sean, for welcoming me and introducing me. You spoke about my legal practice, but in fact, my dream was originally to become professor of international law. And I wrote my PhD dissertation on codification of international law and started to teach. But then I had a feeling that I didn't have any practice, any experience. I felt like assistant in surgery, Department of Surgery, who never did any operation. This led me to join the Foreign Ministry International Law Department. It's really a pleasure, at the same time honor for me, to address you today, dear fellow members of the American Society. It's an honor because this is a series of lectures named after Charles Brower. And I have known him for over 20 years. In fact, we met in January 1999 for the first time in this city, not far away, in the World Bank building. He was a lead counsel representing the claimant, Czechoslovak Commercial Bank, or CSOB. And I was just a legal advisor of Slovakia's foreign ministry who provided expert opinion in that case, as this was a case against Slovak Republic. And I provided an expert opinion on the issue whether the bilateral investment treaty, which was concluded between Czech Republic and Slovakia just few weeks before the dissolution of federation, was a treaty in force or not. And imagine, Slovakia published a treaty in its collection of laws as a treaty in force, while Czech Republic did not publish it. And then in 1997, when proceedings were launched, the positions completely changed. Czech Republic expert presented opinion that the treaty was in force, while Slovakia, through my opinion, argued that the treaty was not in force and its publication in the collection, official collection, was by mistake. Let me stress that I have not taken inconsistent views on this issue. When Slovakia published the BIT as a treaty in force, I was not the legal advisor, but acting permanent representative to the United Nations in New York, and also acting as its agent before the International Court of Justice in this now well-known case, Gabčíkovo-Naďmároš project. The tribunal chaired by another distinguished American lawyer, professor, and later my colleague on the bench of the World Court, Professor Bergenthal, concluded that uncertainties relating to the entry into force of the BIT prevent that instrument from providing a sound basis upon which to found the parties' consent to jurisdiction. So it seems that I may have convinced at least partly the tribunal. But it was Charles who was happy with the outcome, because at the end the tribunal said that since when two foreign ministries concluded a kind of loan agreement as part of the consolidation agreement with the Czechoslovak Commercial Bank and referred to the BIT, that respondent gave its consent with exit arbitration. So I was not anymore involved in the case, but Charles was happy, and in particular client, with the award, because at that time it was the largest award in exit history, over 800 million, and it's still featuring on the website of Biden Case, law firm representing the claimant. The next time I crossed my path with Charles was in 2009. Charles was appointed by the claimant, and I was appointed by the respondent in an ad hoc ancestral arbitration between a company called HIC, Health Insurance Center in Eastern Europe, and Slovakia. And the tribunal was chaired by Frank Berman. The proceedings concluded in 2011, and Charles authored a rather lengthy dissenting opinion. And since 2015, I have had the pleasure to work with Charles in 3 cases still pending before the International Court of Justice. He has been appointed judge ad hoc, as I said, 3 times, and you might be surprised to hear, always by the respondent. These 3 appointments make him the most frequently appointed national of the United States as judge ad hoc. And there is now a chance for him to get at least 1 more appointment, since the government, which has appointed him in the past, has another pending case before the court in which it has not yet chosen a judge ad hoc. So this collaboration with him and the friendship I have formed with him over the years make me all the more honored to have been invited to deliver today the 2019 Bravo Lecture on International Dispute Resolution. His illustrious contribution to international dispute settlement extend far beyond the many cases he has decided, whether through his scholarly writings as past president of this distinguished society, or in his many philanthropic endeavors. He has fostered a tradition of open and honest dialogue on international dispute resolution. I am thus most delighted to join the most distinguished lineup of previous speakers mentioned by Sean to this lecture and offer my humble contribution before the American society. I am about to speak about the century of dispute settlements through international law, 2019, the role of multilateralism. Originally, another speaker was announced, and he was supposed to speak about the rising of the global south. I do not feel qualified to talk about that. Certainly, Judge Yusuf, now president of the court, has published, in particular, on Pan-Africanism and international law. But when I look at the current situation, I see rather a rising China. And it would be for another colleague from our court to speak about Chinese approach to international law, as she lectured on that in the Hague Academy of International Law in the past. What I know about Chinese approaches is that China still strongly advocates direct negotiations. But while I agree that the most efficient way of settling disputes is through negotiations, I am convinced that in addition to that, what we need are third-party settlement dispute mechanism available when a dispute cannot be settled through negotiations. And in fact, the existence of these kind of mechanisms may be even conducive to bring the parties to a settlement. But I have maintained a part of the topic, and I'm going to speak about 100 years of settlement of international disputes, and in particular, the role of multilateralism. This year is an important milestone in international law for several reasons. For instance, in May, we will mark 50 years since the adoption of the Vienna Convention on the Law of Treaties, which has become familiar to us all and is a cornerstone of the international legal system. In June, we will mark the 120th anniversary of the first Hague Peace Conference, the significance of which I shall briefly touch on later. But most importantly, for our present purposes, 2019 also marks 100 years since the Paris or Versailles Peace Conference, where states were finally able to accept both the concept of a general international organization and a general world court for the first time in treaties that would actually enter into force. It is not exactly clear where the phrase world court originates. It is only current in English and not in other prominent languages, whether official languages of the United Nations or not. However, in his contribution to a volume in celebration of the court's 50th anniversary, Professor Georges Abissab attributes the phrase to Menleo Hudson, a former president of this society who earlier served as the fourth American judge in the Permanent Court of International Justice and later on as the first US member of the International Law Commission. It is, however, in my view, an appropriate nickname for an institution such as the court, charged as the principal judicial organ of the United Nations with the role of resolving states' disputes according to international legal rules and, if I may say, acting in the name of the international community as a whole. The name World Court reflects the important role multilateralism has come to play, not only in the settlement of disputes of major importance that states submit to the International Court of Justice, but in the resolution of all sorts of disputes between states. In my contribution, I will focus on the history and the evolution of such dispute resolution, reflecting on the role multilateralism has played in the development of diverse array of international fora for dispute resolution. And I hope that this sketch, historical sketch, will recall us that what was discussed maybe 100 years ago may be still of some relevance for discussions today in particular fields of dispute settlement, and I have in mind mostly investor-state dispute settlement mechanism. In the context of the development of international dispute resolution, multilateralism can be seen as a shorthand for and of a reflection of cooperation between states driven by two impulses. The first is institutionalization, and the creation of pre-existing rules, structures, and ultimately institutions for dispute resolution that reflect the needs of states and the characteristics of the dispute to be resolved. And the second is universalization. This refers not only to the generally increasing number of states which have agreed to submit to it, but also to the harmonization and unification of the rules to be applied in dispute resolution and the development of international law as a whole. As the history of some key institutions in international dispute resolution shows, these twin impulses have always been present and have led to the diverse and generally effective system of dispute resolution. But allow me to start at the beginning. The current breadth of multilateral fora for international dispute resolution shares its origin with the general practice of settlement of international disputes in accordance with international law. This history shows that the current multilateral fora have emerged from the twin impulses of states to institutionalize and to universalize procedures for resolution of disputes. States have subjected in advance ever more categories of disputes to third-party resolution according to predetermined rules and expanded this system to cover ever more subject matters. These impulses flowed from states' increasing willingness to resort to interstate arbitration over the course of the 19th century. Before 1850, agreements in advance to submit international legal disputes to arbitration, so-called compromissory clauses, were, in the words of Manley Hudson, hardly known. By the end of that century, interstate arbitrations had become much more frequent, and states were beginning to conclude multilateral conventions with compromissory clauses. For example, Article 16 of the Universal Postal Convention of 1874, or another article in the Convention on the Railway Freight Transportation of October 1890. Attempts were made at further institutionalization of international dispute resolution in the Americas. For example, a multilateral arbitration treaty was signed by 11 American states in 1890, but was never brought into force. In 1907, 5 Central American states created a Central American Court of Justice with compulsory jurisdiction between them, but this court was short-lived, ceased to exist when its founding treaty lapsed in accordance with this term in 1918. The rapid development of international arbitration in the late 19th century culminated in the first Hague Peace Conference. The conference brought together a representative of 23 states at a palace in the woods in The Hague, the residence of the Dutch monarch. The Russian circular of 11 January 1899 proposed the conference, and I quote, the twin goals of seeking without delay means for putting a limit to the progressive increase of military and naval armaments, and I quote again, preparing the way for a discussion of the questions relating to the possibility of preventing armed conflicts by the pacific means at the disposal of international diplomacy. Specifically, the relevant items on Tsar Nicholas II proposed list of subjects for the conference emphasize these goals, proposing that the conference accept in principle the employment of good offices of mediation and facultative arbitration in cases lending themselves thereto, with the object of preventing armed conflicts between nations. To come to an understanding with respect to the mode of applying these good offices and to establish a uniform practice in using them. At the conference, both goals of institutionalization and universalization of the peaceful resolution of disputes were plainly on the agenda. Already in 1899, the international community was considering a permanent institutionalization of dispute settlements through the creation of a permanent court of general, if not compulsory jurisdiction. The primary goal was to create a real international tribunal, un vrai tribunal international, for the settlement of international disputes in accordance with international law. For example, Secretary of State John Milton Hay instructed the US delegation to propose a permanent international court akin to the present World Court. Delegates in The Hague discussed proposals for an institution that would have included permanent, full-time salaried judges named by governments, but these proposals were abandoned for practical rather than principled reasons. Neither 1899 nor the 1907 Hague conferences culminated in the creation of a permanent world court along the lines we know it now, but its accomplishments are not to be diminished. In 1899, the Peace Conference achieved the creation of the Permanent Court of Arbitration with a standing bureau to support the arrangements of individual arbitral tribunals and has become an institution of fundamental importance in the evolution of international dispute settlement. Today, the PCA has 122 contracting parties following the accession of Mongolia to one or both of its founding conventions. These accomplishments were important steps to increase the role of multilateralism in international dispute resolution. However, states were not fully satisfied with the Permanent Court of Arbitration achieved in 1899. For example, at the 1907 Peace Conference in The Hague, one delegate of the United States, former ambassador to the United Kingdom, Joseph Hodge-Court, spoke directly to the drawbacks of the PCA. And I quote him, because it's interesting. The fact that there was nothing permanent or continuous or connected in the sessions of the court or in the adjudication of the cases submitted to it has been an obvious source of weakness and want of prestige in the tribunal. Each trial it had before it has been wholly independent of every other, and its occasional utterances, widely distant in point of time and disconnected in subject matter, have not gone far towards constituting a consistent body of international law or of valuable contribution to international law, which ought to emanate from an international tribunal representing the power and might of all the nations. In fact, it has thus far been a court only in name, a framework for the selection of referees for each particular case, never consisting of the same judges. It has done great good as far as it has been permitted to work at all, but our efforts should be to try and make a tribunal which shall be the medium of vastly greater and constantly increasing benefit to the nations and to the mankind at large. He spoke instead and consistently with the position of the United States already in 1899 in favor of a permanent court with regular sessions, permanent judges, a jurisprudence constante, and I quote, the authority of the united voice of the nations, end of quote. So while the Permanent Court of Arbitration has created through a multilateral process an institution for international dispute settlement, it had not created a truly multilateral institution for resolution of international legal disputes. In principle, the 1907 Peace Conference considered the idea to supplement the PCA, established 8 years earlier, with a so-called Court of Arbitral Justice that would have these court-like features, specifically permanent judges who would hear every case. However, the conference was unable to agree on the modality of selecting these permanent judges. The creation of a true world court would only become possible once the idea of a more general international organization was already accepted. The structure of the League of Nations agreed at Versailles would provide a solution to the problem that doomed the Court of Arbitral Justice. Judges were to be elected simultaneously by the League Assembly and the League Council. As with today's United Nations, the League Assembly was composed of all members of the League, and the Council had a limited composition that privileged the principal allied and associated powers. Simultaneous election allowed the interests of both the so-called great powers and the less powerful states to be preserved, as a candidate for the office of a judge must be acceptable to both the Assembly and the Council. And this grand compromise was proposed by the founding president of this society, Eli Root, the delegate of the Committee of Juries, who was tasked with drafting the statute of the Permanent Court of International Justice. It is rather ironic that the World Court, at the same time, and the role played by American lawyers, the United States also worked hard to create this court, but it was not accepted by political organs back in this country. Nevertheless, the Permanent Court of International Justice was an, if I may so, instant hit. Speaking to American professors of international relations in August 1926, the then registrar and future member of the Permanent Court, the older brother of much more famous former Secretary General of the UN, Dag Hammarskjöld, Ake Hammarskjöld, reported that in its first 4 years, the court has heard as many cases as the PCA had seen in its first 25 years. Interestingly, an important part of the case law of the Permanent Court were disputes that would now be considered to relate to investment protection. Over the course of its existence, the Permanent Court heard at least 12 cases that today might have made their way before an investor state arbitral tribunal. Perhaps the most illustrious examples are the German interests in Polish Upper Silesia or Factory at Chorzów cases, which require the Permanent Court to hand down a total of 4 judgments and 1 order on interim measures of protection concerning the same nitrogen plant in Chorzów, a city of some 70,000 inhabitants then at the outskirts of Katowice, whose name is, as a result of these 2 cases, familiar to all international lawyers, although occasionally it is still mispronounced. The lasting impact of these and other cases reflect the importance of the court status as a multilateral institution. According to a useful study of the impact of jurisprudence of the Permanent Court on investment arbitration, at least 13 decisions of the Permanent Court of International Justice have been cited in awards of investment tribunals. Of course, many of these are familiar to you. As I mentioned earlier, a well-reasoned discussion of the consequences of responsibility, or rather breach, almost always include Factory at Chorzów. When the question of whether a dispute arises, we turn quickly to Mavromati's Palestine concessions. The Permanent Court has also made a lasting impact on the substantive law of investment protection. For example, many investment tribunals have cited certain German interests in Polish Upper Silesia for the proposition that contractual rights are property susceptible to expropriation. Similarly, some tribunals have cited Polish Upper Silesia or Oskarszyn cases on questions relating to indirect expropriations. The enduring value of these judgments is rooted in the true multilateralism that distinguishes the court, Permanent Court of International Justice, and today's court from the PCA. The Permanent Court of International Justice had originally 11 and then since 1936, 15 members who, together with the judges ad hoc, would consider cases. 18th century French author Marquis de Condorcet teaches us that all other things being equal, the greater the number of decision makers suffices to increase the chance of high quality decisions. Although there might be some limits as far as the size is concerned. And in my view, maybe law of the sea tribunal is a little bit too large and does not need 23 lawyers to consider a particular case. More importantly, however, the judges of the Permanent Court were, in the words of the statute, to represent the main forms of civilization and the principal legal systems of the world, and were elected by the representative organs of the League, thus guaranteeing the stronger legitimacy of that institution and its members. This provision, which was retained in the statute of the present court, ensures the multilateral character of the court. As someone who has experienced this aspect firsthand, I can assure you that this makes deliberations of the court a quite remarkable process. Under Article 5 of the resolution concerning internal judicial practice of the court, the main deliberation proceeds with each of the judges declaring their views in reverse order of seniority. The result would be of great interest to a scholar of comparative legal method, as the legal traditions of the world converge to solve the same problem. The inclusivity of the process tends to ensure, I hope, the better quality of the result, but finally it's for states and scholars to judge. While multilateralism gave the Permanent Court its legitimacy and the durability of its legacy, it also gave the court work in a more direct way, through the use of its advisory jurisdiction. Article 14 of the League Covenant succinctly provided that the Permanent Court could give an advisory opinion upon any dispute or question referred to it by the Council or by the Assembly, and gave the World Court an important role in the machinery of multilateralism. At first, the idea that an international judicial organ could have an advisory function was controversial. A French commentator, writing in the 30s, described its inclusion as bizarrerie. Many were concerned that the power to give advisory opinion would detract from the court's judicial character. However, as Manley Hudson remarked in a 1925 opinion piece in the New York Times, and I quote him, "Few foresaw the great service to be performed by the court in giving advisory opinions to the Council of the League of Nations." End of quote. Indeed, the advisory jurisdiction of the Permanent Court would become well used. Compared to the present court, the Permanent Court's advisory caseload was much heavier. In its 18 years of activity between 1922 and early 1940, the Permanent Court gave 27 advisory opinions. It was only last month that the present court matched this record with its Chagos advisory opinion, taking over 4 times as many years to get there. This is even more remarkable given the relatively limited scope of the Permanent Court's advisory jurisdiction. Under both Article 14 of the League of Covenant and Chapter 4, which was added to the statute of the Permanent Court during its revision in 1929, only the Council or assembly could request advisory opinions. By contrast, 16 organizations, in addition to several United Nations organs, are authorized under the Charter of the United Nations to submit a request. One interesting contrast is that while 4 permanent courts' advisory opinions relate to the institutional law of the International Labour Organization, the ILO has requested none in its own right from the present court. While none of the permanent court's advisory opinions are among its most cited decisions, except for perhaps Eastern Karelia, the work fed to the court by the League played an important role in confirming the value of an institution like the World Court. The permanent court was not to last forever, but the idea of a World Court would remain. During the Second World War, the permanent court had no cases, understandably, but nevertheless remained formally available to states. In 1942, Chile and Argentina even concluded a treaty containing a compromissory clause for the submission of disputes to the permanent court. The details of this period are reflected in the permanent court's 16th and final report, covering the period 39-45, but nevertheless listed on the court's website among annual reports. For those interested in this moment of history, the details of how the court coped with the Nazi occupation of The Hague make it a very interesting read. Early on in the discussions of what was to be done with the permanent court, it was agreed that whatever world court would exist should have significant continuity with the permanent court. It was also agreed at Dumbarton Oaks that the court would be an organ of the United Nations organization, in contrast to the status of the permanent court as an independent institution. These principles are now enshrined in the UN Charter, which makes it clear both that the International Court of Justice is the principal judicial organ of the United Nations and that its statute is based on that of the permanent court. These two decisions had important consequences for the relationship between multilateralism and the court. On the one hand, the tradition of the permanent court would be maintained. The present court is very much the successor of the permanent court, and its jurisprudence continues to guide our work today. At the same time, being an organ of the UN expands the reach and the legitimacy of the court. Article 93 of the Charter makes clear that all members of the United Nations are ipso facto parties to the statute of the court. Thus, the problem that, for example, the executive branch was never able to convince the US Senate to join the statute of the permanent court was eliminated. Acceptance of the existence of, but not of the jurisdiction of the World Court became an integral part of the package of multilateralism. As with its predecessor, the new court continued to make important contributions to international law. No doubt you will be familiar with the court's greatest hits. The judgment in the North Sea continental shelf cases is still studied for the court's works on custom international law. The ruling of the court in the Barcelona traction case on the inability of the state of nationality of shareholders to exercise diplomatic protection over the corporation of a different nationality also remains of current value. The court's judgment in the Gabčíkov and Maros, the case in which I was, as I said, involved for the first time, but before the bench, not on the bench, remains of lasting importance in the law of state responsibility and the law of treaties. I do not feel I need dwell on this point further, although Professor Alan Pellet's 2013 Laliv lecture on the jurisprudence of the court in the Exit Tribunals Awards may be of interest. Needless to say, the fact that the court is elected by the United Nations to represent the diversity of its member states continues to be one of its greatest assets and a reason others respect, I hope, its judgments. Allow me instead to comment on two other ways multilateralism has been important in the work of the court. The present court has continued the tradition of contributing to multilateralism through its advisory jurisdiction. A key distinction, however, is the subject matter of that contribution. The bulk of advisory opinions handed down by the permanent court responded to questions asked in the exercise of dispute resolution powers of the League political organ. These were useful and contributed to multilateral resolution of interstate disputes, but did not have the same contribution to the legal framework for multilateralism as would the ICJ. The present court played an essential role in construction of the legal framework for multilateralism in its early years. The court is mindful of its powers to contribute, and as is frequently recalled, the court's answer to a request for an advisory opinion represents its participation in the activities of the United Nations, although one may occasionally raise a question whether in all these cases that was really so. In its first 2 decades, the court gave 12 advisory opinions, majority of them concerning the institutional law of the United Nations or one of its specialized agencies. Some of these opinions remain either widely cited, foundational for the law of international organizations, or both. For example, in that of conditions of admission opinion, the court advised the General Assembly that Article 4 of the Charter limited the factors the Assembly could consider when evaluating an application for membership to those for which its text provides. The court was clear. The political character of an organ cannot release it from the observance of treaty provisions established by the Charter when they constitute limitations on its powers or criteria for its decisions. In its second advisory opinion, the famous reparations opinion, the court determined that the United Nations had the capacity to make a claim for reparations under international law from a state for injury to one of its agents. In doing so, it cemented the doctrine of implied powers, foundational to international organizations law, stating that the United Nations must be deemed to have those powers which, though not expressly provided in the Charter, are conferred upon it by necessary implication as being essential to the performance of its duties. In 1954, the court delivered its advisory opinion in the awards of the Administrative Tribunal case, where it held that, and I quote, the General Assembly has not the right on any grounds to refuse to give effect to an award of compensation made by the Administrative Tribunal of the United Nations, a ruling of much comfort to UN staff members. The establishment of the United Nations gave multilateralism an additional expanded role in international dispute resolution through increased multilateral engagement with the content of customary international law, and the court has been an important partner in this work. One of the innovations of the UN Charter was to give the General Assembly a mandate to undertake studies to encourage the progressive development of international law and its codification. This resulted in the creation of the International Law Commission, with which you are familiar, and you can see interesting photo panels in this hotel celebrating the anniversary. The work of the Commission has been of frequent relevance to the court. The court also influenced the work of the Commission itself, because special rapporteurs in the Commission relied on a number of pronouncements of the International Court of Justice. Subsequently, the court, once codification of different areas of international law advanced, the court has been called upon to interpret and apply conventions that have resulted from the Commission's work, most recently, for instance, the Vienna Convention on Concert Relations in the Jadau case, currently under deliberation. The court has also looked to these conventions to determine the content of customary international law, whether a convention codifies existing law. This was the situation in the North Sea continental shelf cases, where the court looked to the Geneva Convention on the continental shelf to inform its analysis, even though the Federal Republic of Germany was not party to it. But the court has also extensively relied on the studies of the Commission as a subsidiary means to determine the law under Article 38, paragraph 1d of the court statute. According to one academic survey of citation of the doctrine by the court, the works of the International Law Commission account for roughly 3/4 of the infrequent references to the doctrine in the court's judgment and advisory opinions. This reflects the reality that the multilateral process embodied by the Commission and its dialogue with the Sixth Committee of the General Assembly is often a reliable means of revealing the content of customary international law. Thus, for example, in the Gabčíkov-Naďmároš case, the court referred several times to the Commission's then ongoing work on responsibility of states for international wrongful acts in order to determine the content of customary international law. And subsequently, when the Commission was finalizing its work on articles on state responsibility, it relied on the pronouncements of the court in 1997. In fact, the Commission considered this judgment in its work. Multilateralism therefore contributes to the work of the court by providing useful codifications of customary international law, and the court gives back to multilateral process by considering, interpreting, and ultimately applying such instruments of codification and progressive development. I would not do justice to the story of multilateralism in international dispute settlement if I played favorites by discussing only the contributions of the institution of which I am a member. As I have been describing, the so-called proliferation of international courts and tribunals, which has been studied extensively, in particular at the turn of this century, has surely been well underway for more lengthy period. With these developments came the now familiar issue of the so-called fragmentation of international law, but also that of whether states are better served by resolving their disputes in bilateral or multilateral fora. With these insights in mind, I would like to turn now to prime examples of multilateral dispute settlement mechanism reflecting on their successes and challenges, as well as on how they reflect the twin impulses of universalization and institutionalization. Let me start first with the International Center for Settlement of Investment Disputes. The center originates from the desire of states to come up with multilateral approaches to promote private foreign investment. In an era of decolonization and increasing tensions between the East and West, the UN General Assembly heeded the call of John Fitzgerald Kennedy and designated 1960s as the United Nations Development Decade, calling upon states to intensify their efforts to obtain substantial increases in growth rates for developing countries. Yet real and perceived political risks were considered an important impediment to the increased flow of resources to developing countries. For many reasons, the World Bank was ideally situated to consider proposals to meet these objectives. Multilateralism in international economic law, above all, largely developed out of the 1944 Bretton Woods Conference and the creation of the International Bank for Reconstruction and Development, which was part of and remains within the World Bank Group. Furthermore, as Antonio Parra recalls, The multilateral character of the bank and its position as a financial intermediary between capital exporting and capital importing countries helped to inspire confidence in its impartiality on the part of both foreign investors and their host governments. I need not to lecture this audience about the various proposals that were not retained, or even to detail the key role that General Counsel of the World Bank, Aaron Broches, played in fashioning the text of the 1966 Convention on the Settlement of Investment Disputes between States and Nationals of other states. What is clear from this process and from Mr. Broches' working paper, however, is the intent to establish an international institution that encourages the flow of private capital and to depoliticize the settlement of investment disputes, echoing the desire of states earlier in the century to submit more disputes to resolution according to predictable legal rules. While originally a very limited number of states ratified the Exit Convention, states have slowly but steadily accepted the idea of joining this multilateral institution, Exit, as shown last year by Mexico's becoming the 154th member state. All states have the opportunity to have their cases administered by the center. More importantly, as members, states obtain access to investment dispute settlement under the convention and the additional facility. And there is ever-growing number of cases administered by the center coming from all regions of the world, now even from Western Europe, which was not the situation some less than 10 years ago. Of course, the booming recourse to center is may be seen as a welcome development, but others may have a little bit more critical view. It depends on one's view about free trade and investor-state dispute settlement more broadly. But again, states are masters of their own destiny in shaping the future of the Center for Settlement of Disputes, which is not the case of all institutional arbitration institutions. States can actively participate in the center through their representation on the Administrative Council and in related endeavors. And I was pleased to learn that state participation thus far has been rather large and diverse and remarkably comprehensive in the process of amendment of exit arbitration rules. And I note without surprise that Judge Brower made his own individual contribution and submission. This process is yet another example of the driving force of institution building through the skillful cooperation of states in the fields of international trade and commerce. The success of international arbitration over recent decades has had the effects beyond exit. I mentioned earlier Ake Hammarskjöld's observation on the relatively low case load of the PCA in its early years. And subsequently to his remarks, for almost 70 years, there was practically no workload for that institution. But I would be remiss not to highlight as well the spectacular revival of the Permanent Code of International Arbitration in the last 20 years. Originally designated to settle interstate disputes, the caseload of the institutional registry became extremely thin following the establishment of the PCIJ, as I already mentioned. If we, however, look at the most recent statistics for the whole of 2018, we see that Permanent Court of Arbitration has administered 190 cases, most of which 112 are investor-state arbitrations. And this is due to the policy change when the Permanent Court of Arbitration decided at the turn of the century to open its door to other types of disputes, in particular investment disputes, but subsequently also to provide services, for instance, for intra-state arbitration, if I can call ABA arbitration this way. The impression these statistics I have mentioned provide and confirm that the Permanent Court and the International Court of Justice keep the Peace Palace in use as never before. What does the future hold for the Permanent Court? I'm not perhaps in the best position to judge, but I can only applaud my colleagues in the Peace Palace for developing internally such a great expertise in providing services to international dispute settlement and offering the states yet another top-class forum to resolve their disputes. Another chapter in the role of multilateralism was the creation of the International Tribunal for the Law of the Sea. As was the goal of the framers of the Permanent Court, the World Court is a court where disputes are decided in accordance with international law. From time to time, this will mean, however, that the court is liable to take decisions that are not perhaps popular with one or the other group of states or many states. And I think I do not need to elaborate on South West Africa cases decided in 1966. The timing of this unfortunate decision could hardly have been worse. It fueled calls a few years later at the third UN Conference on the Law of the Sea for a new court. This new court, the International Tribunal for the Law of the Sea, alongside the International Court of Justice and the two types of arbitral tribunals contemplated in the Convention, is one of the options for states for the settlement of legal disputes arising under the Convention. The ITLOS was thus seen by many delegates as a competitor to the International Court of Justice. Unsurprisingly, its creation did not escape criticism. For example, writing in 1995, a year before the first ITLOS judges were elected, Judge Shigeru Oda, then member of the International Court of Justice, expressed his view that the creation of ITLOS, and I quote him, will prove to have been a great mistake, and that the second court would diminish uniformity in the rule of law. However, some particular aspects of the tribunal represent important developments in the institutionalization of international dispute resolution. Three facets of the tribunal's jurisdiction are worth mentioning in this respect. The first two are the tribunal's competence to indicate provisional measures pending the establishment of an arbitral tribunal, and then the issue of prompt release of vessels and crews. And in fact, these part of the activities predominantly occupied the International Tribunal for the Law of the Sea in the last 23 years. The third feature is the tribunal's seabed dispute chamber, which even Judge Oda was able then to applaud. The seabed dispute chamber has compulsory jurisdiction over several categories of disputes relating to activities in the area and to the activities of the International Seabed Authority. Of course, the expectations when the tribunal was established as far as the commencement of the activities on the seabed and extraction of resources did not materialize. Perhaps it was over-optimistic. But still, this function is quite important. The seabed dispute chamber is the specialized organ established to resolve legal disputes relating specifically to a multilateral regime of intended universal scope. While today the chamber has only given one advisory opinion, I expect it may become of increasing importance when seabed mining under the convention ultimately begins. Taken together, these examples clearly reflect the tendency of multilateralism to result in specialized dispute settlement institutions precisely geared to meet states' needs. Like many predictions of the grand danger of fragmentation of international law, Judge Oda's prognosis was perhaps a touch overblown. Instead, the ITLOS has taken up a place alongside the International Court of Justice as a specialized institution to which states may resort. In its nearly 23 years of existence, 25 cases were submitted to ITLOS. Of these, only 7 contentious cases were heard by the tribunal on the merits, while in the same period the ICJ heard 12 cases relating to UNCLOS. I raise these statistics not to defend the court's honor or pride, but rather to demonstrate that states see value in both the court and the tribunal. Indeed, in its 2 delimitation cases, the ITLOS relied on the jurisprudence of the International Court of Justice, particularly the delimitation methodology enunciated by the court in its Black Sea Maritime delimitation judgment. And the International Court of Justice has cited the 2012 ITLOS judgment in the Bangladesh-Myanmar case, once in the 2012 judgment in maritime and territorial maritime dispute between Nicaragua and Colombia, and again last year in a maritime dispute between Costa Rica and Nicaragua. Today, it is clear that rather than some kind of threat, the International Tribunal for the Law of the Sea is a complement to the International Court of Justice. This brings me today, or shall I say next week, to discussions on what types of reforms should be pursued as far as investor-state dispute settlement mechanism is to be further pursued when the delegates of states meet in New York within UNCITRAL, the core legal body of the UN system in the field of international trade and commercial law, which has contributed so much also in the field of international arbitration. It would not be an overstatement to know that the debate in the 2 prior phases has been rather heated, with states strongly disagreeing on the way forward. Some states appear to favor selective bilateral reforms, while others made it clear that they were seeking systemic multilateral reforms. Let me say a few words about what may be seen as elephant in the room, the proposal to create a multilateral investment court, which the EU is pursuing both within and beyond the confines of UNCITRAL. After lengthy consultations and internal deliberations, the European Commission launched in 2015 its Trade for All strategy, specifying it would henceforth include in its modernized investment treaties investment court systems and work towards the establishment of a multilateral investment court. The European Commission now argues that a standing 2-tier mechanism composed of a permanent first instance tribunal, an appellate tribunal, is the only reform that can effectively address concerns about the system and should thus be the one UNCITRAL pursues. I'm not going to comment on the benefits or drawbacks of such a multilateral investment court, even if I know that my friend and colleague, Judge Brauer, has strong views about this topic, and I'm pretty sure he's going to present them next week during the discussions. Rather, I will limit my observations to 2 points. Here again, we see the driving forces of institutionalization and universalization in full effect, for better or worse. First, one's position on a permanent court perhaps depends greatly upon how he or she views free trade and the substantive protections offered to foreign investors. To take one example, some ardent critics of the current system, who initially championed the establishment of international public courts, have recently expressed much more skepticism towards the EU proposal, especially as they have come to realize this means further entrenching of an institutionalization of the system of investment arbitration into international law. The second point I would like to make concerns universality. It is obvious that a great part of multilateral investment court success, if created, depends on it being multilateral. We do not know yet how many states will accept the EU proposal, although 4 of them have already agreed to the investment court system model, and other negotiations are underway. But there will need to be substantial participation in terms of the number of both states and also in number of international investment treaties which could be invoked before such a court if established. Fortunately, the EU has developed through its various iterations of the proposals, inspired by comments of practitioners and academics, one way to make this possible. The signing of an instrument establishing the standing mechanism, and second, a specific notification opt-in system that particular treaties would be subject to jurisdiction of that mechanism. On this point, one can observe, once more, the pervasive influence of multilateralism's past achievements, that is the reliance on these multilateral institutions and also on transparency. I also note that transfer of jurisdiction from arbitral tribunals to the standing court, if established, could be similar to the one operated by Article 36, paragraph 5 of the Statute of the International Court of Justice, which refers to declarations submitted in the times of the Permanent Court of International Justice. It is beyond my expertise and knowledge to mention another example of multilateralism when the system seems to have provided good services, and this is within the World Trade Organization, although I understand that the system is currently under pressure. The story I have tried to describe to you today is by no means a complete picture of how multilateralism has played an ever-increasing role in international dispute settlement. I have not mentioned the growth and successes of jurisdictional institutions that resolve another type of disputes between individuals and states, but also occasionally between states, and these are regional human rights courts in response to complaints, as I said, either by individuals or states. But I hope that my lecture has demonstrated the usefulness and the practical value of pursuing dispute settlement in the context of multilateral institution. And this society has played an important role at the very beginning in the times of particularly the Second Hague Peace Conference, and also when the Permanent Court of International Justice was established. And I do hope that this society will continue strongly to support multilateralism, despite voices now growing in certain quarters which prefer more unilateral than multilateral approaches to the problems which the world is facing today. Thank you very much for your kind attention, and I hope that I have left a little bit of time to take some of your questions, as I am not claiming immunities. Although, as member of the International Court of Justice, I enjoy immunities both in the Netherlands and even in this country. Thank you.
Thank you, Judge Tomka, for that wonderful lecture. We do have about 10 minutes for questions from the audience. If you're interested in asking a question of Judge Tomka, I invite you to come to the microphone here in the center of the aisle. If you do, identify yourself and keep your question reasonably brief if possible. While people are thinking about doing that, I will go ahead and pose my own question to the judge. You alluded to the fact that there have been questions raised about the advisory opinions coming to the court. And it's interesting in the context of a conversation about multilateralism to observe that some of the concerns expressed have been that sometimes the advisory opinions requested of the court look a bit like a bilateral dispute in disguise. And one can think about the so-called Israeli wall case, which one might conceptualize as a Palestine versus Israel matter. One could think about the Kosovo advisory opinion as a Serbia versus Kosovo matter, or as you alluded to, the Chagos Archipelago advisory opinion. Some have looked at that as a Mauritius versus United King matter. Now, one of the answers often is, well, the General Assembly is asking for the advice of the court, but given the breadth of the Assembly's mandate and remit, one might say, well, it's always the case that you could shoehorn a bilateral dispute into the Assembly process. So my question to you is just to expound a bit on that aspect of the discussion, Judge, bearing in mind, of course, the desire, presumably, of the court to protect its own institutional integrity. And don't be shy, the rest of you, with questions.
Thank you very much for the question. I spoke about the advisory opinions during the times of the Permanent Court of International Justice and ICJ. Do not think that I'm advocating for more requests. I think requests are to be submitted when the organ really needs these legal opinions from the court. I can speak quite openly, since I have expressed these views in my declarations attached to the last two advisory opinions. Leaving aside the construction of the wall in the occupied Palestinian territories, one could raise the question whether it would be bilateral state-to-state dispute, because then you qualify at least one entity involved as a state, and that entity achieved the status of observer state in the United Nations only later on. But I clearly indicated in my opinion in the Kosovo advisory opinion, and that was my position from the very beginning, that the General Assembly did not need the opinion because the General Assembly did not consider issues relating to Kosovo. It was within the remit, and still is, of the Security Council. The only resolutions adopted by the General Assembly in relation to Kosovo prior to 2010 were budgetary resolutions. It's true that the power of the General Assembly to ask or is not limited to the issues which occur in the conduct of the activities. But it was clear that the request was formulated by Serbia. It was decided by the divided vote. And what better illustrates that the General Assembly did not really need this opinion is the fact that once the court rendered its opinion in July 2010, General Assembly in September 9, 2010, adopted a very short resolution in which it acknowledged the content of the opinion, and the item was closed. So that was the situation. I referred to earlier to Eastern Karelia as perhaps the advisory opinion from the times of the Permanent Court of International Justice is most frequently invoked by those who argue that the court should, in the exercise of its advisory function, to keep in mind that advisory proceedings should not be a way of bringing bilateral disputes in case that the court would not have jurisdiction because of a lack of consent. I wrote briefly in my declaration appended to the Chagos advisory opinion. I do not disagree with the answers given by the court, although I expressed my reservations on the legal basis for answering, particularly in relation to the second question, that for me it's law of the Charter of the United Nations and not the rules on state responsibility, which concerns issues of Chagos Archipelago and the completion of the process. But I pointed to the fact that for 50 years, the issue had not been discussed in the General Assembly. Questions were formulated by Mauritius upon advice of legal team working for the government of Mauritius. Of course, formally, the draft resolution was presented by the African group in the United Nations. So far, no action has yet been taken in the General Assembly. I don't know when the General Assembly is going to consider this advisory opinion, which was sent to the Secretary General. We will see. But it seems that there is a growing possibility that certain matters which cannot be brought as disputed issues before the court in the exercise of its contentious jurisdiction can be submitted through requests for advisory opinions, because under the rules of procedure of the General Assembly, resolutions of the General Assembly are adopted by majority vote, and only those who voted in favor and those who opposed are counted for that purpose. So I rather advocate and continue to advocate that there should be more acceptances of compulsory jurisdiction of the court, that the current situation when we have only 73 acceptances, and some of them very narrow, like Egyptian, it's almost like a compromissory clause, because Egypt accepts jurisdiction of the court only for disputes relating to the Suez Canal. So that states, if they advocate the rule of law, which is still aspiration, not yet a reality in international relations, should be ready to accept more broadly court jurisdiction by declarations, to review their limitations on the scope of acceptance. And I hope that one day, but it is going to take much longer period, maybe decades, the International Court of Justice will be the real principal organ of the United Nations in the similar way as the Court of Justice of the European Union. Because all members of the European Union have to accept, they have no option. So ideal situation would be that all members of the United Nations have to be subject to the court jurisdiction. But still, in today's world, the system adopted in 1920 is a compromise when the proposal for compulsory jurisdiction was rejected, and opt-in system adopted as a compromise, it still applies. And despite the great declarations of states, member states, for instance, the World Summit outcome in 2005, or 2012 declaration adopted at the higher level event on rule of law, international relations, encouraging states to make declarations and to withdraw their reservations. These were rather exhortations which have not been followed much. In fact, since 2005 until 2012, there were 2 or 3 declarations new, one of them Germany, the other by Dominica, because Dominica wished to bring, or some people in Dominica wished to bring a dispute to the court relating to permanent representative of that country, a Russian businessman in Geneva. So they accepted the jurisdiction, and then 2 weeks later, when Prime Minister learned about that, the case was withdrawn. And since 2012, high-level event on the rule of law, there have been maybe 4 or 5 new declarations accepting the court jurisdiction, and that's not a very high number. Of course, some of those states which made this declaration later on realized that it was useful to make such a declaration. Let me mention the case of East Timor, because it allowed East Timor to bring a dispute with Australia when certain actions were taken by Australian authorities in relation to lawyer who worked for Timor-Leste in the pending arbitral proceedings before the Permanent Court of Arbitration. But I see there is interest for some other questions and comments. I apologize for my rather lengthy answer.
I suggest we take both questions and then let the judge.
Okay. Judge Tomka, it's an honor to hear from you. I was struck during your speech about your discussion of the Peace Palace and the neighbors in the Peace Palace that reflect perhaps one of the basic choices that states have when they decide to go to formal dispute settlement. Should we go to arbitration, or should we go to adjudication before the International Court of Justice? And you, of course, are one of the few who have done both interstate arbitrations and been a long-standing judge. And I was hoping you could reflect a little bit. I'm sure many of us are curious here, practitioners as well as academics, about your views on the differences, the advantages and the disadvantages for states of going to one or the other option. And perhaps just to direct it a little more, your experience as a judge hearing cases in arbitration and in adjudication, evidence gathering, for example, I think is very interesting. And the second, if you were to peer a little bit behind the veil, deliberations and the decision-making process, is it different in the International Court of Justice versus in arbitration? Thanks.
Can we take the second question too?
Hi, I'm Nutul Pirasha. I'm a Fulbright scholar at George Washington University. You indicated a desirability for the permanent court for investment disputes. And my research on MFN clauses indicates that ICSID, which was created for creating a level playing field, the tribunals have largely failed to create a level playing field, and any errors that have been committed have been to the detriment of investors. So what I'm thinking is what depoliticized and these arbitrators which were depoliticized and there was consent from the investor in electing them, these tribunals, if they couldn't achieve this result, how would a more politicized body where the investors have no say, they have no consent, how would these tribunals achieve a level playing field? The permanent court, sorry, how would that achieve a level playing field?
Thank you. Answering the first comment, the question, of course, PCA, leaving aside investor-state disputes, and that was basically the main reason for so great increase in the activities of the permanent court of arbitration, has provided arbitration services, registry services to several arbitrations state to state. I think one of the reasons is the fact that is the system adopted during the third conference on the law of the sea. Because states, when becoming party to the convention, or anytime subsequently, can make a choice, either accepting jurisdiction of ICJ or law of the sea tribunal, or arbitral tribunal under Annex 7. If the state have not made such a declaration, or the declarations do not coincide, the fallback position, that is jurisdiction in principle, of the arbitral tribunal. This explains a good number of law of the sea arbitrations administered by a permanent court of arbitration. Occasionally, this may be due to provisions in bilateral treaties. For instance, in these Kishenganga arbitration between Pakistan and India, this was due to the fact that when in 1960 they signed Indus Waters Treaty, but international institution played a major role in bringing these two countries to agreement, and it was the World Bank. They agreed on dispute settlement provisions, either technical independent experts for certain categories or court of arbitration. And once this court of arbitration was, the procedure was instituted by Pakistan, then members of the court of arbitration agreed that the services are to be provided, support services by the permanent court of arbitration. What are the advantages and disadvantages going to the court or to the arbitral tribunal? Going to the court, it's cheaper because the services are provided free of charge. It's from the United Nations budget. You do not pay any fees for the work of the court. Even judge ad hoc is paid by the court and from the budget. It perhaps provides, through participation of 15 members, perhaps better chance for a more balanced judgment, but I'm not criticizing decisions of arbitral tribunals. I think they have also, these arbitral tribunals rendered well-reasoned decisions. But theoretically still, when you have a larger number, but not excessively large, this may provide for more objective and balanced view. Occasionally, states agree on arbitration because they wish to provide a little bit more flexibility, and in a particular situation, they may not necessarily be in favor of court applying its well-established jurisprudence. What I have in mind is this now famous arbitration between Croatia and Slovenia. To my understanding, Slovenia was not very much inclined to accept jurisdiction of the International Court of Justice for the purposes of this case, because Slovenia wished that the organ which is going to decide could take into account what they, I think, referred to finally in the arbitration agreement, in addition to international equity. So it loss perhaps was also for that reason not acceptable so much. And the other factor which could have played a role was the fact that earlier there was a Croat national member of the International Law of the Sea Tribunal, even vice president at a certain moment. So for particular reason, in particular, as far as the determination of the applicable law, at the end, the compromise was reached to establish this tribunal. And of course, again, an international institution played a role in that, and that was a European Union, European Commission, which contributed to successful conclusion of the arbitration agreement, although I would not say that necessarily there is a great success in implementation. There is still, I think, a pending dispute between the parties as far as the application of that award is concerned. I can mention another case. It was between Netherlands and Belgium, presided over by Dame Rosalind Higgins. And what was interesting in that case was that the parties agreed that the tribunal would decide the matter on the basis of written submissions, no hearing, unless the tribunal considered that was strictly necessary. So that was another reason. But now, going to the second question, I don't think that there is a concern of not having equal playing field if investment tribunal is established and state decides on the election of members of that investment court or tribunal. Why I do think so? Nobody complains that only states elect members of the human rights courts. And individuals bring disputes to the European Court of Human Rights, but members of that court are elected by members of the Parliamentary Assembly of the Council of Europe. And civic society and NGOs play no role in the election. They may play a little bit of a role in campaigning for one another, drawing attention to some aspects of the activities of that candidate, perhaps. But the decision is by states. So experience shows that human rights courts can provide a balanced approach, and frequently states are so-called losing their human rights cases in international human rights courts. So this experience for me undermines criticism that investors would have no say in selecting of those who would serve in investment courts if such courts are to be established. Thank you.
Well, we have come to expect in the annual Charles Brouwer Lecture on International Dispute Resolution a very carefully crafted analysis of a particular area of international dispute resolution and a thoughtful assessment of where we've come from and where we're heading. I have to say, I think today's lecture by Judge Tomka on largely multilateral aspects of the international dispute system really has been a deep dive for us into the ICJ, the PCIJ, and a very interesting connection with the whole area of investor-state dispute resolution. So please join me in thanking our Charles Brouwer lecturer, Peter Tomka.
Well done.